Good morning, everyone. My name is Clara and I'll be your moderator. Today's webinar is sponsored by NatRoad's Platinum Partner Packer. Whether it's moving freight across the nation or going the last mile, their DAF trucks are always delivering. Now, let me introduce our guest speaker, Gillian Bristow, Legal Practitioner Director at Bristow Legal. In this webinar, Gillian will discuss fuel levies and price reviews, force majeure and subcontracting. Now, before I hand over to Gillian to begin her presentation, may I request that you put your microphone on silent to avoid any disturbances during the webinar. Like always, we'd love to hear from you during today's presentation. If you have any questions, please feel free to type your questions into the question and answer section at the bottom of your screen. You may send in your questions at any time during the presentation. We'll be answering questions at the end of the session. Now, without any further ado, I'd like to kick things off by welcoming Gillian. Over to you.
Thanks so much, Clara. It's lovely to be here, albeit in a virtual sense. We've missed out on a lot of that personal contact this year in the pandemic that we know has struck all of us and affected us in all sorts of ways. Today, we're going to be talking about contracts, and I'm just going to try and move to the next slide here. Here we go. So we're going to be talking about contracts today, and I know that's a pretty dry sort of a topic, but it's also a very important one, obviously, for all transport operators. Often when I talk about contracts and transport contracts, I'm talking about risk and reward. And very often we focus on risk. Risk is things like indemnity clauses and insurance and what you're actually having to perform in order to get paid. But today's session's a bit different. Today we're really talking about, at least in the first part of the session, on how you get paid and what you get paid with your contract. Now, I'm just having a bit of a manipulation of this slide here because I seem to have come back to the main screen. So I just want to go back a slide here. So we're going to be talking today about three things. First of all, price review, and within price review, fuel levies themselves, and then price reviews at various stages through contracts. We then, because it's become such a big topic, going to briefly talk about force majeure on the basis that pandemics, of course, are usually a force majeure event, and what happens to your contracts and your contractual relationships in the event of a force majeure. And then thirdly, we're going to talk about subcontracting, but today in a bit of a different sense. We're going to be talking about some of the risks to you getting paid in circumstances where you subcontract without consent. And my reason for wanting to talk about this is that there is a recent case from late 2019, which is a reminder to all of us that subcontracting without consent is very risky. And then, as Clara said, we're going to round up with some questions, and you're more than welcome to type any questions as we go into the box, and we'll do our best to get to them at the end. So, beginning with price review. The first thing I want to talk about is the two aspects of price review, essentially fuel levies and also price review itself. You'll appreciate that across a long-term contract, you're going to see all sorts of variability in both fuel prices and also in other of your cost inputs like labour and like the price of vehicles and government charges. And that's why in any long-term contract, you need to make sure that there are written provisions that deal with how you're going to manage these changes to costs. So beginning with the first and the most volatile element of providing a transport service, and that's fuel. Now, all of us have kind of grown up with the idea that the price of fuel is volatile. And we know that just by looking at, driving past petrol stations. But in the sense that it's volatile, we very much got used to the idea that the price of fuel goes up over time. And until the COVID pandemic this year, I don't think any of us would have foreseen such a very large drop over such a very short time in the fuel price. And this is where I turn into Alan Kohler for those of you who follow the ABC, just to give you some kind of indication of what we've seen with the terminal gate price across the last 3 years. And you can see the sudden drop that we experienced in around March, April this year, and a bit of a climb back up, but essentially intense volatility in the fuel price and a major decline. Now, this has created its very own issues. Obviously, for transport operators, a lower fuel price is in general a good thing. It's a major, probably 20 to 30% component of your costs. But where it gets tricky is how this is managed within any fuel levies that either you impose or that are part of contracts that you have in place with major customers. And I understand that the NatRoad Help Desk has had quite a lot of queries from people who've had issues because the fuel levy clauses that they've signed up to in major contracts actually allow an adjustment downwards of the price when the fuel price falls. So, things that can go wrong with fuel levy clauses and things that we would generally see in practice as a problem. The first thing I want to talk about, and this goes for any clause in any contract, is the idea of certainty. You cannot properly enforce any clause in a contract if it's not clear how that clause works. Now, just as an example, having a clause that says the price can be varied based on changes in the price of diesel fuel is an unhelpful sort of clause, because so what? It really doesn't tell you what is supposed to happen to your price if there's a variation in the price of diesel fuel. The other issue is that sometimes clauses won't go through the how, what, when, where. How often can you review the price based on fuel movements? Can you do it monthly? Can you do it quarterly? How do you go about reviewing it? What is it based on? For example, sorry, I'm just going to go back to the right slide here. For example, are we talking about changes in the fuel price for diesel, or are we talking about changes in the fuel price for unleaded fuel? Are we talking about, sorry, I'm having a few troubles with these slides here. Are we talking about the fuel price, for example, the terminal gate price, or are we talking about the retail price? How are we measuring it? What website are we using? At what point is it being measured? Is it an average price across a month? Is it a point in time price? And finally, you need to also have a base price against which you're benchmarking. Finally, you need to look at the clause itself, and this is where people were getting into trouble at the beginning of the pandemic. You need to look at the clause you've got and see whether it allows the price to go down as well as up. For example, a fuel levy clause that says the transport operator may vary the price based on movements in diesel fuel AIP gate prices. If you had a clause like that, then it's pretty good from your perspective because it uses the word may. So in other words, if you don't want to change your price, you don't have to. But if the clause says the price will be varied or must be varied based on changes in the price, then if the price goes down, then your fuel levy will go down and may even become negative. You also need to look very carefully at the terminology as to whether it says varied or increased. So a fuel levy clause that says the transport operator may increase the price based on changes in the fuel price, then obviously you would argue that that doesn't allow prices to be decreased, only increased. So it's always going to depend on the exact wording that's used, and what's important is looking at those words, so making sure whether or not it goes up or down, whether it's up to you to increase the price or whether it automatically changes, and that you have enough information in that clause to allow you to properly work out what the change is, so that you've linked it to a particular sort of fuel. You've found where you're going to source the price. You've got a base price in there, and it says how frequently you're going to do the calculation. Now, the other thing that can sometimes inadvertently go wrong is that people use clauses without actually checking the calculation in it. I've not infrequently seen fuel levy clauses that have got a formula in them, and if you actually perform the calculation, you discover that the fraction is upside down, and that in fact, if the fuel price goes up and you put the numbers into the formula, then in fact the fuel levy goes negative. So always, if you've got a formula, put some pretend numbers in there and make sure that it makes sense. Even better, in a contract, include an example that shows how you mean the clause to work, so that anyone looking at that clause can immediately see how the calculation is supposed to be performed and what you were intending to happen in the event that fuel prices go up or down. So that's essentially fuel levy clauses. And then let's talk about price more generally. In long-term contracts, you will normally see some kind of a provision to allow a price review. And often if you're reviewing a contract that a customer's asking you to sign, you'll see a price review formula and you'll think, okay, fine, there's a price review mechanism in here, all is good. But again, you need to look really carefully at these clauses. First of all, we return to that theme of certainty. You need to make sure the how, what, when, where, why is in there. In other words, how often will you be reviewing the price? What are you going to use as your measure for how you're going to calculate this? Who's going to perform the calculation? And when will it start? And I'm just going to unpack a little bit of that. The first thing I'm going to say is around CPI. So often I will see very vague clauses in agreements that say, on each anniversary of this agreement, all of the rates in Schedule B will be increased based on movements in the CPI. The CPI is not a thing. The CPI is a group of numbers that are published by the Bureau of Statistics. When people say the CPI, what they usually mean is the CPI all groups average of 8 capital cities index. And that is a specific number that you can find on the website. And the CPI is made up of movements in a whole basket of products across the economy. And it does make a difference. First of all, you must say which part of the CPI you're talking about. And I want to illustrate with my next couple of Alan Kohler slides that in fact it makes a difference which CPI you pick if you choose to use CPI movements as the basis for any change in your pricing. So this first slide here shows you movements in the CPI all groups index in the last 3 years or so. And you can see that if, for example, you had a contract where the prices were going to be reviewed in June 2020, you're going to discover, if you picked CPI all groups, that in fact you're either not going to get an increase or you're going to get a decrease depending on how your contract is worded, because you can see that quite sharp dip that we saw in June 2020. Now, if you hadn't picked CPI all groups and you'd picked another part of the CPI group of statistics, things could be worse for you. One component of the CPI index that you sometimes see used in contracts is the CPI transport component. Now, the CPI transport component effectively tracks inputs into transport. So it tracks fuel and it tracks costs of vehicles and it tracks vehicle maintenance. If you had a contract that had a price review clause based on CPI transport in June this year, have a look what would have happened. You can see much more of a decline in the CPI transport index as at June 2020. Now, this is because of fuel. So fuel makes up a large proportion of the transport component of the CPI. So hence you can see that you'd be feeling pretty sad and sorry for yourself if you picked CPI transport as your measure for a price review and you'd just gone through that exercise. So what other alternatives are there other than the CPI for trying to have price review mechanisms in contracts? One of the other options is there's a private provider out of Melbourne called TransEco, and you often see their indices used as part of price review in major contracts. So TransEco publish 4 separate indices that are designed specifically for use in transport. They have a long haul and a short haul index, and they have the same indices with and without tolls. And just because, again, I'm playing Alan Kohler here, I can show you what would happen if you had used a TransEco index, line haul without tolls, as at June 2020. So you're seeing something that's less volatile than the transport index, and it sort of looks a bit like the CPI index. So that's one of the things that you need to bear in mind when you're looking at price review clauses, is simply which index you're linking your prices to. Now, there are a couple of other technical things to bear in mind when you are considering price review clauses. And I've got these on the next slide. Be really careful that you are actually entitled to a price review. Often the way contracts that you see from customers are worded essentially gives discretion as to whether or not you're allowed the price review. So it says price review as the heading of the clause, and then it says something like what I've got on the screen here. The rates will be reviewed using the formula in Schedule 5, having regard to, and then it lists a whole bunch of stuff. Now, essentially, all these sort of discretionary factors simply mean that you are not guaranteed that you will get the price review or the increase. It's basically saying your customer is allowed to think about the price review mechanism, think about the clause, but is also entitled to think about things like economic and performance trends. So what it really means is you will still be left in a position where you need to negotiate with your customer in order to get a rate review. So be careful of that. Other issues to be careful of are seeing, again, as we talked about with the fuel levies, seeing whether the clause is worded in such a way as your price can go down as well as up. Again, I've got on the slide here that idea of discretion, where in fact the customer might allow you to adjust your price rather than will allow you to check your price. As I said with the fuel levy clauses, make sure the clause makes sense and that any of the calculations or formulas in the clause actually work if you stick numbers into the formula. Also, be very careful with another issue that's coming up more and more often in contracts, and that's this idea of somehow the customer being entitled to service credits in the event that you haven't achieved KPIs for the year. So you might get to 30th of June and think that you're entitled to a price review, but at the same time have your customer come back and say that under the small print in clause 16, because you didn't achieve the KPIs in March and April, that you're not entitled to, or you might be entitled to the price review, but they've got a cross claim because they get service credits for your failure to achieve the KPIs in particular months. So that's essentially price review in a nutshell. I'm now going to move on to talk about a couple of other issues that I mentioned at the start. The first is this idea of force majeure. And we've had lots of questions about this since COVID, simply because COVID threw everything into chaos. Now, the law around contract and force majeure is that, generally speaking, if you haven't got a clause that deals with unforeseen events or a force majeure clause, then the only circumstances in which you're excused from performing the contract is if the contract is frustrated. And frustrated is not about your emotions about it. Frustrated is about where you basically cannot perform the contract because what you're being asked to do is so different from what you signed up for that parties should be excused from their obligations under the contract. Now, that's a really, really high hurdle. And in fact, there were a bunch of cases in the UK going back decades where the Suez Canal was obstructed and people had to go right the way around rather than through the Suez Canal. And the court said, well, look, no, sorry, that is not frustration. Okay, it's difficult to perform and it's taking you way longer and it's way more expensive, but you can still do it. So sorry, that contract's on foot and you need to perform it, even though it's going to be way more difficult and way more expensive. So because of that, it's important that in major long-term contracts, you have provisions that deal with unforeseen events. Of course, we've all been scrabbling through force majeure clauses since COVID, looking for words like epidemic and pandemic. So certainly going forward, make sure that contracts that you've got on foot are really specific about excusing performance in the event of unforeseen events like pandemics and epidemics. So important to check contracts, see what they say about force majeure. Look at in the contract what classifies as force majeure, and then also look at what happens under the contract if there's a force majeure event. Finally, another thing to be really, really careful about if you're looking at a force majeure clause is make sure that it does not suspend your customer's obligation to pay. What you don't want is a clause where your customer's entitled to say, it's a pandemic, all obligations are suspended. One of my obligations is to pay you for things you've done. Oh no, I'm not going to. My obligations are suspended. So always make sure that the right to payment is not suspended in the event of a force majeure or a pandemic or anything similar that's outside of your control. Now, the last area that I want to talk about today is subcontracting. Now, this doesn't sound on the face of it like it would be very interesting, but it's certainly an issue to think about when you are reviewing contracts. So most transport operators in the course of carrying on their business need to make use of subcontractors. It goes without saying that subcontractors are very useful where you've got excess of work or you've got seasonal work and you need to be able to put someone on for a short term or for a particular job to help you fulfill your contractual obligations. But before you do so, think about what your contracts actually say about subcontracting. Now, in your contracts, there are three possibilities. Your contract might say, yes, absolutely, you're allowed to subcontract services under this contract. It might say, no, you're not allowed to subcontract work at all, or make it subject to various prerequisites before you're allowed to subcontract, or it might say nothing at all about subcontracting. So I want to touch on each of these, and I also want to talk about, as I mentioned at the start, a recent case about why this is so important. In my experience, the most common contractual provisions are in the centre here. Almost all major customers will say you may not subcontract the provision of services, or they say you may only subcontract the provision of services if you get the prior written consent of the customer. And usually that's impractical because the reason that you're trying to get a subcontractor involved is because you've got a sudden issue with getting the work done using your existing workforce. You've got an excess of work, a particular employee's out of action, etc. It's very unusual for a contract to fall into that left-hand category of a contract allowing expressly for you to subcontract work. You do sometimes see contracts that say nothing at all about it, which is the situation on the right hand of that particular diagram. If your contract says that you may subcontract with consent, think about whether you've actually got that consent, and also look at other issues in the contract where it says what you've got to do and what insurance cover your subcontractor has to have in order to be allowed to perform services under the contract. I've put on this slide the sort of clause that you would commonly encounter in a contract. So in this particular slide, it says the subcontractor may subcontract the services provided it gives the principal at least 7 days prior written notice of any subcontract they propose to enter into. And then you'll almost always see the next part of this clause. That's basically saying it doesn't matter whether you subcontract or not. If you get someone else to perform the services, you're going to be responsible for them or for any acts or omissions or negligence of the subcontractor. Here's a clause that prohibits subcontracting. So the supplier must not, again, without the prior written consent, subcontract the performance of any obligations or otherwise arrange for another person to perform any part of the agreement. Now, why is all of this important? It's important because if you subcontract services in a situation where you don't have permission or you haven't followed the rules in the contract before you do so, you may find that you are not entitled to get paid. So I've mentioned on the slide there a recent case from 2019, and this is a New South Wales Court of Appeal. So it's a Court of Appeal and it's a really important judgment. Now, what happened in this case was that Advanced National Services was a cleaning company and Daintree Contractors was also a cleaning company. But Daintree Contractors was the principal contractor and it had an agreement to clean various supermarkets and liquor outlets, etc. And it engaged Advanced National Services as its subcontractor. And the contract specifically prohibited assignment or subcontracting without prior written approval. And it said that if Advanced did that, then Daintree could terminate the contract without notice. Now, Advanced National Services presumably didn't read this clause and they proceeded to subcontract about 90% of the work that they undertook to do for Daintree. And then Daintree refused to pay them. There was no question that the cleaning services had been provided. There was no issue as to whether the services were, done well or not done well, etc. Daintree simply said, listen, you were not supposed to subcontract. You did, and we're not going to pay you the $368,000 that we owe you. And the court said, that's fair enough. The contract actually required the contract actually required the services to be performed in a particular manner on certain conditions. And essentially, you were supposed to do the cleaning services yourself, not using a subcontractor, so you did not earn the $368,000. Too bad, so sad. So for these reasons, it's really important that you don't ignore clauses that say you can't subcontract or that you get appropriate consent if you do intend to subcontract. What do you do if your contract doesn't say if you can subcontract or not? I think the safer course of action is going to be that you need consent if your contract doesn't say yes or no to subcontracting. It's very much going to be the case that a court's going to look at it and say, if I engage ABC to provide services, that is the party I want to provide services. I don't want anyone else ABC wants to engage that doesn't actually work for them. I want ABC. So there may be some room to argue that a contract that's silent on subcontracting still allows you to engage some subcontractors, but that's always going to be a risky course of action. So generally speaking, if a contract is silent on whether you can subcontract or not, you shouldn't subcontract without the consent of your customer. Now that's essentially what I was hoping to go through today. I'm spot on my 30 minutes and I've got plenty of time for questions if there are any out there.
Great, thanks, Gillian. So I'm just going to begin answering the questions now. As a reminder, you can still submit your questions through the questions pane in the attendee control panel. I'll be checking them as I'm answering them. So far we've got one question. So Gillian, do you have any suggestions on what to do if a contract becomes unprofitable and I'm losing money whilst I'm doing the work?
That's a good question. Thanks, Clara. So that's always a risk in a long-term contract, especially one where, for example, you've got a price review clause in there and it's not doing any good because the CPI is obviously not helping you, or you don't have a fuel levy clause, or the work's become really difficult. Obviously, if you've got a contract that's unprofitable, the first thing to do is to go to your customer and say, look, this is the situation. I've got this long-term deal with you, but it cannot be done for the price under the contract. And if you can reach an agreement and document an agreement with your customer that fixes the issue, well, that's fantastic. But if you can't, then what you need to do is to try and look for ways that you can exit the contract. And one of the issues with transport contracts, and one way in which they're often very one-sided, is that the customer often doesn't have to give you any work at all, and can exit the contract for convenience. So you'll frequently see a clause in contracts that says at any time the customer giving 60 days written notice can terminate this contract for convenience. What I always suggest to clients that have a contract given to them with that clause is make it mutual. So if that's fair enough for your customer, why is it not fair enough for you? If you were to have a clause like that that says that you, by giving 60 days notice, can exit the contract, then at least it gives you an out in the event that a contract becomes unprofitable across a longer term.
Great, thanks, Gillian. So our second question today is, how do I terminate my contract if it isn't in writing?
Okay, this is a really tricky one. So as you would all know, you don't have to have a written contract. And if you've got a contract that isn't in writing, then it's really difficult to know what the terms of that contract are, because obviously it's what you think you agreed verbally, and it's also something that's come about by conduct, because often there won't ever be that kind of moment in time where you sit in a room and you say, I'll do this for you, and then the customer says, that's fine, and you shake hands. Often the whole contract will have evolved over time and by the behaviour of people across a period of time. But the general rule in a situation where you've got a verbal contract that's quite long-term like that is that either party would be able to exit a contract by giving reasonable notice. But it will be a question to be worked out as to what's reasonable in that situation. So the longer the contract's gone on, possibly the more notice you would have to give in order to be able to exit from that contract. And you'd also want to have a really good look at things like emails and other commitments that you'd made either verbally or in emails as to how long you'd keep doing that work for.
All right, perfect. Thanks for that, Gillian. So those are our only questions today. But yeah, if you have any other questions, anyone who's listening, please send an email through to info@natroad.com.au after the session. Also, the webinar will be uploaded onto our website and the recording will be sent to you via your email. So yeah, that's about it for today. Once again, thank you, Gillian, and thank you everybody for attending today's webinar. We'll catch you next month for our next webinar, and I hope you have a great rest of your day. Thanks, Gillian.
Thanks.